Imagine signing a lease in Virginia believing you understand your rights, only to discover later that cannabis laws, property rules, and local enforcement intersect in ways no one clearly explained. Today, we are breaking down Virginia cannabis laws for renters in a way that is calm, factual, and grounded entirely in law and compliance. This is not about lifestyle. This is not about promotion. This is about understanding where the law actually stands. Here's the context. Virginia's cannabis framework is often misunderstood, especially when it comes to private property. Renters frequently assume that legalization or decriminalization automatically grants protections inside rental housing. Property owners often believe they have absolute authority over cannabis-related restrictions. The truth, as with most areas of law, is more structured and more nuanced. Virginia cannabis laws for renters sit at the intersection of state statutes, landlord-tenant law, local zoning authority, and federal housing rules. If you live in Norfolk or anywhere in Hampton Roads, enforcement practices can differ in meaningful ways. Here's the legal explanation. Under Virginia law, limited personal possession of cannabis is legal for adults. However, the legality of possession does not override private property rules. Landlords in Virginia retain the legal authority to establish lease terms that restrict certain activities on their property, including smoking, odors, and conduct that may affect other tenants or the condition of the unit. Virginia cannabis laws for renters do not create a statutory right to use cannabis inside a rental unit. This distinction is critical. A lease is a binding contract. If the lease prohibits smoking of any substance, cannabis is included even if tobacco is not specifically named. Courts generally defer to lease language unless it conflicts with a protected right. Cannabis use is not a protected right under Virginia housing law. Medical cannabis patients often ask whether their status changes this analysis. At this time, Virginia law does not require landlords to accommodate cannabis use, even for medical purposes, particularly when it involves combustion or odor. Who it affects. This issue affects multiple groups simultaneously. Renters who assume legalization equals permission. Property owners managing multi-unit housing. Public housing residents governed by federal rules. Medical cannabis patients seeking clarity. Local housing authorities enforcing codes. Virginia cannabis laws for renters also affect neighbors, property managers, and local enforcement agencies responding to complaints. Why it matters. Violations related to cannabis in rental housing rarely begin with criminal charges. They usually begin with lease enforcement actions. Notices. Warnings. Lease termination proceedings. In Norfolk and surrounding areas, complaints often stem from odor disputes, not possession itself. Odor complaints can trigger inspections, lease reviews, or referrals to housing authorities. Understanding Virginia cannabis laws for renters allows individuals to make informed decisions that protect housing stability. Here's a scenario. Consider a tenant in Norfolk living in a multi-unit apartment building. Cannabis possession is legal. The lease prohibits smoking. Neighbors complain about odor. Management issues a notice. No arrest occurs. No criminal charge is filed. Yet the tenant faces possible lease termination. This is how cannabis law interacts with housing law in real life. What to watch next? Virginia continues to refine its cannabis framework. Local ordinances, court interpretations, and housing authority policies evolve. Future developments may address non-combustion use, medical accommodation debates, or landlord disclosure requirements. Staying informed is essential. Here's a question for you. Should Virginia law provide clearer statutory protections or disclosures for renters regarding cannabis-related lease restrictions? Put your answer in the comments and keep the discussion respectful and fact-based. If you are a business owner, a property owner, or even someone simply trying to keep a roof over your head, this information matters more than you may realize. Because most legal problems do not begin with handcuffs or courtrooms. They begin quietly. With a misunderstanding. With an assumption. With a lease clause that was never fully read or explained. For a business owner, one unclear policy decision can trigger inspections, complaints, or licensing issues that disrupt years of hard work. For a renter, one moment of confusion about what the law allows versus what a lease restricts can place housing stability at risk. Virginia cannabis law does not operate in isolation. It intersects with contracts, zoning rules, property rights, and local enforcement practices. And those intersections are where people get hurt not because they broke the law, but because they did not fully understand it. This is why education matters. Not fear. Not hype. Not assumptions. Just clear, grounded legal knowledge that allows you to make informed decisions before consequences appear. Whether you are building a business, managing property, or simply trying to protect your family and your future, understanding how Virginia law actually works gives you leverage, stability, and peace of mind. Please like, comment, and subscribe for more Virginia-focused legal breakdowns. For deeper analysis, real-world discussion, and community-driven understanding, visit the Norfolk City Cannabis community and join the discussion forum.